matter of D.E.L.T.A Merseyside and another against Uber Britannia.
This appeal is about the statutory regime for the regulation of the provision of private hire vehicles outside London and Plymouth. I will call them PHVs. They differ from taxicabs because they do not ply for hire. They have to be booked through an operator. The appeal turns on the meaning of the relevant legislation to be found in Part 2 of the Local Government Miscellaneous Provisions Act 1976, as amended, concerning operators of PHVs. An operator is defined as someone who, in the course of business, makes provision for the invitation or acceptance of bookings for a PHV. In the 1970s, this was almost entirely done by telephone, but now online methods of booking occupy an ever-increasing part of the market. An operator, as defined, need not be either the driver or the owner of the PHV. Its regulated activity is just inviting and accepting bookings. The regime laid down by the 1976 Act is essentially a triple lock licensing scheme run by local authorities, whereby each of the operators and drivers of the PHV have to be licensed, as well as the PHV itself. Licenses can impose conditions, and breach of them or breach of the regulations in the 1976 Act itself can be dealt with by the revocation or suspension of licenses. Prior to 1976, bookings for PHVs were accepted by operators under various models. They included the hire contract model, where the operator entered into an immediate contract with the customer to hire the PHV for the requested journey, the agency model, where the operator did the same but only as agent for the driver, incurring no legal liability itself, and the intermediary model, where the operator merely undertook to use its best endeavours to arrange for a PHV to attend at the requested time and place, leaving the customer and the driver to make the contract of hire for the journey. The question on this appeal is whether the 1976 Act makes it unlawful for an operator to accept a booking other than by using the hire contract model, so that the operator undertakes an immediate contractual liability as principal to provide the PHV by way of hire for the requested journey. Uber Britannia Limited, part of the well-known Uber group, say that it does. They brought proceedings against one of their relevant local licensing authorities, Sefton Metropolitan Borough Council, for a declaration to that effect. The council wished to remain neutral, but two rival PHV operators, D.E.L.T.A Merseyside and Visu Holdings Limited, were joined as interveners to argue the case that the 1976 Act imposed no such restriction. Both D.E.L.T.A and Visu use, at least in part, the agency and intermediary models, and, unlike Uber, wish to continue to do so. Uber succeeded at first instance before Mrs. Justice Foster, but her decision was reversed by the Court of Appeal, Lord Justices Lewison and Lewis and Lady Justice Elizabeth Lang. Uber appealed to this court, seeking to restore the declaration they obtained from Mrs. Justice Foster. This court unanimously dismisses Uber's appeal. I give the judgment with which Lord Reid, Lord Leggett and Lord Stevens and Lady Simler all agree. Our reasons are, in summary, as follows. There is nothing in the 1976 Act which, in express terms, imposes the restriction for which Uber contend. Indeed, apart from some bookkeeping obligations and the requirement to hold an operator's licence, the Act imposes no express obligations or restrictions upon operators at all. The reference in the Act to, quotes, accepting a booking, quotes off, does not mean only by contracting as principal to perform the hire. But Uber contends that the suggested restriction, i.e. only to use the hire contract model when accepting bookings, is inherent or implied in the very concept of accepting a booking, when read in the context of Part 2 of the 1976 Act as a whole. And they say that this provides much better protection for customers than a scheme which leaves operators free also to use the agency or intermediary models. This court disagrees. Part 2 of the 1976 Act achieves its regulatory purpose by licensing, not by the imposition of a detailed scheme of rules. The only provision in Part 2 which deals expressly with accepting bookings is section 56(1), which provides that, whenever it is made, a contract for the hire of a PHV is deemed to be made with the operator who accepted the booking of the PHV, whether or not it itself provides the vehicle. This plainly means that whenever a contract of hire of a PHV is actually made, then the operator who accepted the booking is liable as if it were a principal under the contract of hire. Thus, it would make the operator using the agency model liable as if it were the principal, and the operator using the intermediary model liable likewise as principal under any contract of hire later made between the driver and the customer. But if the acceptance of the booking using the intermediary model led to no hire contract, for example because the customer changed her mind or the driver failed to attend, there would be no contract of hire on which section 56(1) could bite. In sharp contrast, if the 1976 Act really did limit operators to using only the hire contract model when accepting bookings, then section 56(1) would be completely redundant. Uber say it was just inserted for the avoidance of doubt, but that is not how it works on the pattern of booking models in widespread use at the time when the Act was passed. For those reasons which do not differ in substance from those of the Court of Appeal, this appeal is dismissed, and the Court is now adjourned.